We have Christy Compagnone, who is our senior managing attorney here at the ACLJ, joining us to talk about and give an update on that case out in Nevada. You'll remember that is the one where the high school student was forced to perform an obscene monologue in one of her high school classes. And we have been suing the school district on behalf of that student and fighting back against the obscenity that was produced in this curriculum. And they actually have some updates from last week as they were out in Nevada. And Jordan, I'll let you take it.
Yeah, I mean, Christy, we know people have seen on this broadcast the video of the mother in this situation going to the school board meeting and being shut down because she read some of the monologue and it was too obscene to read for adults at the school board meeting, but not too obscene for, at the time, 15-year-olds to be reading out in class as part of a required reading that you had to perform other people's monologues.
This will be horrifying for me to read to you, but that will give you perspective on how she must have felt when her teacher required her to memorize this and to act it out in front of her entire class. I don't love you. It's not you. It's just, I don't like your dick, or any dick in that case. I cheated, Joe.
I'm sorry.
This is propaganda that
Forgive
they're
me.
going to put
Excuse me. I don't, thank you so much for your, comment. Forgive me. We're not using profanity. Simply, this is a public meeting. I asked for decorum.
If you don't want me to read it to you, what was that like for my 15-year-old daughter to have to memorize?
So we've been, again, taking the depositions both last week. I think there's more coming this week as well. Tell people where we are in this case and just kind of remind them. It's a great way to remind people about when the ACLJ takes these cases on. It's not just the day that it makes the news and the day that you've got the video of the mother at the school board meeting. We fight these for years if we have to.
Yeah, exactly. So last week we deposed a school administrator, the teacher, and several students. And I'll be honest, it was rather alarming to realize that this kind of ideology is permeating the school completely. The school clearly doesn't see how damaging the sexualization of students is, and they're not willing to take any responsibility for that. In fact, administrators mentioned that all of the students talk this way regularly anyway, and that you can hear it in the hallways. So it doesn't really see why it's that big of a deal. So we really feel like we need to go back next week and take more depositions. We're going to hear from other school officials, and we want to get more of their thoughts on this responsibility of the school. And, do they have a responsibility to protect these students from this rampant sexualization that we're seeing? Even if students are saying that in their own time, can a 14 or 15-year-old actually consent to read that out loud in the classroom? And then we're also going to hopefully talk with more students too, to get their thoughts and reflections on it.
Yeah, I mean, these are the kind of things, if you would have said back in school, even I think unthinkable to say, definitely when we were in school, if I was in school, I mean, you would be in serious trouble. It doesn't matter if you're in a public school, private school, Christian school, regular, any kind of place of education. There's no way you were just walking down the hallway using language like this. I'm sure things have changed. I don't doubt that there's more of this kind of language being used, and you've got social media and places like that. You could, on the one hand, feel for these districts. But if they are pushing it, because I think, Christy, what has to be important here is when they have those students are minors. When this was all happening, they were all minors, so they can't consent to using obscenities, and their parents weren't being asked to consent to their students doing that. And I think that's very important for our audience to kind of understand these distinctions. These cases take time, but it's the parents' rights that we're fighting for here. And it's like in these schools, I know they'd love to have no parental rights, but that's what we're fighting for, is kind of the last hope of parents still having some say in their own children's upbringing in these public schools.
Exactly. How is there possibly a pedagogical interest for the school to be allowing the students to read this? I mean, even in the most sensitive of topics in health ed, you are getting parental consent, even in these public schools. I know for a fact that in several schools in Virginia that they're required to ask permission to read a book such as The Kite Runner, which is actually historical, but it has really sensitive and severe sexualized topics. So why then is it appropriate, just because it's a theater class, that they be able to enact and actually memorize and recite this kind of content? It doesn't make any sense from the purpose of trying to teach them something for theater class. It doesn't make sense in an English class, and it just doesn't have a place in these schools.
Christy, we filed the amended complaint in this last May, so 13 months ago, and we survived a motion to dismiss early, which was a big victory in this case for the student. And now we're in this deposition phase, and I know you said you've got more after what was learned last week, that you need to go back out and depose more individuals. What does the timeline look like on this as we move forward? What comes next in this case?
Absolutely. So at this point, our discovery timeline, which is when we can take the depositions and ask all of the questions and speak with the witnesses, that's ending at the end of June. But we have asked the court for an extension because we believe at this point it's important to bring in an expert witness to actually testify to what is pedagogical. What does that mean? Does this have a legitimate pedagogical interest for this theater classroom? And so if the judge permits, we're going to bring in an expert witness to be able to get that on the record with an expert report. From there, we go into what's called summary judgment briefing. And that's where we will tell the judge there's no evidence here that says that what our complaints facts are not correct. So we say, look, all of the evidence is here. We don't need to go in front of a jury. From just a pure legal standpoint, you can rule for us in favor of us. Whereas the other side will ask for the court to dismiss the claim before it goes to trial. So that's the next real hurdle we've got to face is making it through summary judgment. But of course, at this point, I think there is such a dispute of facts that we are more than likely going to be going to trial here.
All right, folks. Christy, we thank you for that update, and we want you to continue to update our the ACLJ, our supporters, as well, because as they know, I mean, again, 13 months in filing, surviving in motions to dismiss, then doing the depositions, then summary judgment, trying to survive that, and then going to trial. This is that commitment that the ACLJ makes to these issues. And Christy, we appreciate you joining us today on the show. And Will, I mean, again, I think it. As we talk other issues today, we talked about Israel, where we commit to the offices. Of course, here in the United States, we have offices around the country. I'm in the office in Washington, D.C. This week, where Christy usually is. But on these legal issues that are fact-specific, that start out with a parent and a teacher, sometimes, you know what, the school district says, you were right, ACLJ. We shouldn't have let this happen. Can't believe this happened. And, we get a quick fix, a quick win. But, Will, more often than not, these days, we're having to fight because we're fighting up against a very different kind of school district, and school board.
That's right. And unfortunately, it is starting to become a trend where it doesn't just get settled with a simple demand letter, as we've had vast success with for decades at the ACLJ. But many times what we're seeing now is that either the offenses were so egregious that it can't just be remedied by a demand letter, or that the demand letter isn't taken seriously or is ignored, and therefore we have to go to court. And that's why your support of the ACLJ, we're able to offer that service to these families who, just by sending their kids to school, we're never thinking they were going to have to file lawsuits against that school. But we're seeing that's a reality. It's at no cost to them, so they don't have to worry about funds from their pocketbooks not being able to put food on the table or to pay for the life of their family to fight this in court, because the ACLJ members play such a pivotal role in that by allowing us to offer those services at no cost to our clients.